Hello. In this module, we're actually going to start diving into the statute book and going over some of the statutes that exist in Wyoming. One of the references that I will point you to are one of these little books. This year's copy is red, or the 2013 version. And these are just pocket guides. They're statute books. Very, very handy device to have in the field. I usually kept one in my cargo pocket, another one in my car. They're a very good quick reference guide. They're not all inclusive, but they do have most of the statutes that you're going to deal with on the street. So a little bit about our statutes in general. The way they are organized is by title, chapter, and section. The title is the first number, the chapter is the second number, and the section is the final number. They're put together in a very orderly fashion, and so the attempt of this module is to just get you acquainted with the actual statute book itself and how to navigate it. Some of the titles that we're going to talk about: Title 6, Title 14, Title 24, Title 31, and Title 35. This is where you will spend the majority of your time with regard to crimes and offenses in Wyoming, things that you would actually charge. We're not going to go over every statute in detail, quite the contrary, nor is the attempt to get you to memorize every statute. That is what the reference is for. It's simply to be able to navigate through the reference so that you can find the answers that you need. So kind of an overview. Title 6, Chapter 2, Crimes Against the Person, deals with homicide, kidnapping, sex assault, robbery, assault and battery, the justification statute, which we'll talk about today, and human trafficking. Chapter 3, Crimes Against Property. Things like arson, property destruction, burglary, larceny, or theft as it's been renamed, computer crimes, fraud, check fraud, credit card fraud, and theft of identity. Chapter 4, Morals, Decency, and the Family. Here you'll find your prostitution statute, public indecency, obscenity, various other offenses against the family, and desecrating graves and bodies. Chapter 5 are offenses of public administration, offenses by public officials, various hindering of government operations, perjury, and criminal falsification. Chapter 6 of Title 6 are offenses against public peace, disturbances of public order, various nuances, and unlawful conduct within government facilities. Chapter 7, public policy, and the main one that you would potentially deal with there would be gambling. Chapter 8 is our weapons chapter. Deals with weapons offenses, regulation, rifles and shotgun, and how the state regulates and delegates regulation. Title 14 is the next title that we'll look at, and this is your children's title. Chapter 3, and keep in mind the age of majority for this title is 18. Chapter 3 deals with the sale of tobacco and the Child Protection Act. Chapter 6, Juvenile Justice Act and your CHINS statutes. Title 24 only has one chapter in it that would deal with criminal statutes, and that's the general provisions in Chapter 1. Title 31 deals with all your motor traffic law, and there are many in there. Chapter 1, 2, Chapter 4, general offenses and penalties. Chapter 5, regulation of traffic on highways. Chapter 7 deals with driver's licenses. Chapter 8, ID cards. Chapter 9, motor vehicle safety responsibility. Chapter 11, identification of vehicles. And Chapter 13 deals with abandoned vehicles. So throughout your career, you'll probably spend a significant amount of time in Title 31. And finally, Title 35. These are our controlled substances or drug statutes. They're found in Chapter 7 in the Controlled Substances Act. So this is kind of a general overview of the statute book itself. And I'd like to look at a couple statutes in particular before we move on to scenarios. If you have a statute book, please follow along. Look up Title 6, Chapter 1, Section 201. What you'll see on the screen is actually not the statute itself, but the elements of the statute: the act, the intent, and the penalty. 62201 reads as such. A person who knowingly aids or abets in the commission of a felony, who counsels, encourages, hires, commands, or procures a felony to be committed is an accessory before the fact. An accessory before the fact may be indicted, informed against, tried, and convicted as if he were a principal. May be indicted, informed against, tried, and convicted either before or after, and whether or not the principal offender is indicted, informed against, tried, or convicted, and, upon conviction, is subject to the same punishment and penalties as are prescribed by law for the punishment of the principal. So the act itself is that the individual needs to aid or abet in the commission of the crime, or counsel, encourage, hire, command, or procure that this felony be committed. They have to do it knowingly. A common example that is used is a girlfriend allows her boyfriend to use her car. She does not know that the boyfriend is going down to the local 7-Eleven to rob it. This would not be an accessory before the fact because she had no knowledge of the incident. However, if the girlfriend knew that her boyfriend was going to the 7-Eleven to rob the place, then she could be charged as an accessory before the fact in that she aided in the commission of that felony by providing a vehicle. It does carry with it the same punishment as a felony, as the felony that's charged with the principal or the individual that actually commits the crime. And it is irregardless of what happens to the individual that actually commits the crime, whether or not they are charged or convicted. The second statute that I'd like to look at with you is 61202. 61202 deals with the concept of being under the influence while committing a crime. The title of it is Under the Influence, Not a Defense. Self-induced intoxication of the defendant is not a defense to a criminal charge except to the extent that in any prosecution evidence of self-induced intoxication of the defendant may be offered when it is relevant to negate the existence of a specific intent which is an element of the crime. Intoxication is self-induced if it is caused by substances which the defendant knows or ought to know have the tendency to cause intoxication, in which he knowingly and voluntarily introduced or allowed to be introduced into his body unless they were introduced pursuant to medical advice. The fact that the defendant is dependent upon the intoxicating substance is not relevant in determining whether his intoxication is self-induced. So in this instance, the act is the intoxication of the defendant, and the intent is that it's self-induced. This is not a crime, but rather a provisional statute, or procedural statute, meaning it gives us guidance on how we deal with intoxication with regard to charging. Keep in mind that this is something that the attorneys are going to use in court. Someone who is impaired, for instance, and charged with first-degree murder may argue that because of their impairment, they could not have premeditated the offense. But it is not confined to homicide. This can be used anytime that you have specific intent as an element of a crime, and they can argue that the intoxication negated that specific intent, that element of the crime. It also does not mean that they can simply remove the allegation of specific intent. It means that they get to argue it in court. That concludes this module.